Good morning, everybody. Welcome to the CanesInSight podcast powered by Anijar and Levine Accident Attorneys. New developments in the Miami, Wisconsin lawsuit. Miami has moved to dismiss Wisconsin's lawsuit. We'll explain what all that means. Pete's got a new edition of the work, been doing some digging. He's got some stuff to talk about here as we prepare for the scrimmage tomorrow. Just a lot of stuff to get into with this team, man. But first, I want to talk about some folks who know a little bit about these kind of motions, and that is Anijar and Levine Accident Attorneys. If you or someone you care about has been injured in an accident, you could be entitled to significant compensation. Dial 1-800-747-FREE, 1-800-747-3733. Take back control of your life with Anijar and Levine. Pete, get in there.
Good morning, D. Excited to hear your thoughts here on this Xavier Lucas situation. You've been pretty strong for months here that obviously Miami did nothing wrong, and we've kind of been talking through this Wisconsin lawsuit as people are trying to figure out what's going to happen with it. And as you mentioned in the beginning, there big development yesterday as our buddy Brett McMurphy is reporting that Miami is expected to file a lawsuit, or expected to file a motion to dismiss the Xavier Lucas lawsuit filed by Wisconsin. And again, as we understand, the lawsuit alleged Miami interfered with a binding rev sharing contract that's not legal yet, involving the Badgers and DB Xavier Lucas.
Yeah, and look, this motion to dismiss has been filed. So they were expected to do it when this was posted. It has since been filed. I have not seen, let me do my usual disclaimers, I have not seen the full motion to dismiss. This was filed in Wisconsin State Court. I have to go dig it up, but I have not seen it. I don't think it's been posted publicly that I've seen, but I wanted to just give my thoughts on what I do know. So, Pete, as I share my screen here, I will pull up what's publicly available on my end, which is basically like the first page or so. The introduction was posted. Here we go. Let's see. So here we go. You got the first couple pages, the introduction. And as someone who's written a million of these things, usually in your introduction, you're going to lay out really your arguments in summary form. So you're not going to have all the case law that you might rely on, some of the detail, but you're going to at least preview all the arguments you're going to make and the general theme and narrative of the motion. So if you're going to have a part of this and an incomplete part, this is what you want. But, as far as like projecting success and all that, there's a long way to go here. You got to read the full motion. You got to read the cases side. And then, of course, you got to see what comes back the other way. So I don't want to overstate what we're looking here. I just want to give you a feel for what Miami is arguing. So basics as far as what the motion to dismiss represents. I would call this like you're trying to get like a first round knockout here in layman's terms. So basically, you hear the term discovery a lot, right? That's something you hear. These guys want to avoid discovery or whatever it is. Discovery is the fact-finding part of the case where you're trying to find out what actually happened and obtain facts to ultimately help your case if you move for summary judgment down the road or if you ultimately go to trial. So that's like your depositions. When you see people sitting down and answering questions under oath, not in a courtroom, but like in a conference room or whatever, that's going to be typically your deposition. Then the paper discovery, the production of documents, maybe the answering of written questions. This is all part of the discovery fact-finding process. So the motion to dismiss is different than that because with the motion to dismiss, you have to accept everything that's being alleged as true. So you're saying, all right, Wisconsin, let's assume that everything you just said in your complaint is actually the fact. We're not saying it's the fact, but for the purposes of this motion to dismiss, we are accepting all of that as the fact. You still don't state a valid legal claim because for whatever legal reason, it fails, right? So it's a unique motion in terms of there's no facts, like there's no real facts involved. This is just accepting their facts as true and finding legal deficiencies in what they're saying. And if you succeed, you win right off the top. You either avoid discovery totally, or maybe you cut it off really early and the case is done right off the bat. Sometimes a motion to dismiss might knock the case out without prejudice, and then the party who filed the complaint might refile to say certain magic words or to change the way that they put the case to get the complaint together to withstand a motion to dismiss. So it's not always a successful first round knockout. Sometimes it's just a first round knockdown and they're allowed to get up. So that's just kind of where we're at. It's a very early situation. What Miami is saying here, and they make a few arguments. One argument is about personal jurisdiction. Obviously, this is in Wisconsin State Court. So this is going to be the home court for Wisconsin. There's home field advantage, right? You don't want to be in state court, which is the home of your opponent. You'd rather be either in your own hometown or at least in federal court, which is a United States district court judge. So in this case, we're talking about state court. You want to get out of here. So what Miami is saying is that basically the Wisconsin state court does not have personal jurisdiction over Miami as a defendant. Miami can't be hailed into court here for this claim. So it's a very legal, technical thing. Again, different than, hey, did they interfere with Xavier Lucas's NIL contract or not? It's just this is a specific legal issue. And what they're saying, it's twofold. Number one, they're saying we're not at home in Wisconsin, just for the kind of general personal jurisdiction. This is not our home turf. Therefore, you can't just call us in here because we're at home in Wisconsin like you would if it was in Florida state court, right? The Wisconsin court doesn't generally have personal jurisdiction over Miami because we're not at home here. It's not our state of incorporation. This isn't our principal place of business. This is not where we're at. Wisconsin's made some arguments that because Miami takes admissions from Wisconsin and does other things in Wisconsin, that they're subject to personal jurisdiction there. And Miami basically says, and they use the exact words, borderline frivolous, which is pretty strong language. I'm sure every lawyer in this chat has used that phrase a bunch of times. But use that when you think you have a pretty good argument. The other aspect would be specific specific jurisdiction. Appreciate you, Birdstone. Like and subscribe to the show. Shout out to the villains. Appreciate your support as always. One of the lawyers is saying 57105 sanction these guys for how frivolous it is. But Martin Quinn saying we need trial by combat, Mario versus Fickle. That'd be a good fight. So anyways, the other part is specific jurisdiction. Basically saying Miami did things in Wisconsin that led to the lawsuit, and therefore it's appropriate that Miami is subject to being hailed there to court in Wisconsin because Miami went into Wisconsin, did something that caused this whole problem. And what Miami is saying is, even if you take what Wisconsin is saying is true, all this happened when Xavier Lucas was in Florida. None of that happened when he was in Wisconsin. And the whole, the big claim, or one of the big claims in the Xavier Lucas lawsuit, was that a Miami staff member met with Xavier Lucas's family member. And Miami's saying, well, even if you take that as true, again, remember, there's a motion to dismiss. So you're accepting these allegations, which you think are false, as true. You're saying, even if you admit that that's true or accept that it's true, that would have happened in Florida, that meeting in Broward County. So that doesn't provide the basis for specific jurisdiction. Another claim by Wisconsin is basically look, we felt the effects of what you did in Wisconsin because we're in Wisconsin. We're going to run all Xavier Lucas's ads in Wisconsin, and we can't do it because of what you did. So the effects of your conduct were felt in Wisconsin. That allows us to bring you in here. And what Miami's saying is that that's kind of an outdated test. Since 2014, the Supreme Court said that you don't look at the effects on the plaintiff. You look at what the defendant is doing towards Wisconsin, like the state of Wisconsin, right? What are defendant's actions into the state? And in this case, Miami's saying basically there's none. So this sounds like legalese, technical stuff. But this is what you see in a motion to dismiss. Miami's basically saying we don't belong in Wisconsin state court. Get us out of here. You're just trying to get the home court advantage, and you aren't entitled to do so. So that's kind of the first part of this. The other part is more substantive, I think, which is Miami saying, look, forget the personal jurisdiction part of it. You are alleging that the University of Miami is interfering with Wisconsin's contract with Xavier Lucas, NIL contract. There was no contract. It was all contingent. It was a memorandum of understanding contingent on this settlement, which has since been approved, but at the time you didn't know it was going to be approved, right? And Xavier Lucas didn't intend to be bound by that MOU. It was just something he signed with the understanding that maybe something happens down the road. So therefore, even if we accept all this stuff as true, there was no contract. And therefore we could not have tortiously interfered with the contract. So that's the other basis to dismiss, which is more substantive, because that doesn't just go to like what court you're in. That goes to the actual merits of the case in a way. Last argument that at least that I saw in the introduction. Again, I'm just going off the introduction, which is usually going to lay out all the arguments. Miami says that Wisconsin is basically asking the court for a declaration of whether the contract's legit, and stepping away from the lawsuit and what's written. The fact of the matter, the reason Wisconsin is doing this more than anything is to have that Big Ten revenue sharing contract, which is a form contract provided by the conference that binds players to these schools. Wisconsin wants the court to admit, hey, this is a legit contract.
I was going to say, this would essentially legitimize that deal, no?
Right, and that's what they want.
If they were to win it.
And that's what they want, because we've talked about before when we talked about this case, there's no damages. Like Miami, first of all, you cannot get Xavier Lucas from Miami to Wisconsin.
There's one damage. There's one damage. Wisconsin's defensive backfield.
Right, which they can't say because they can't say it's pay for play. Because in all the big suits, this is what I've always said about this case, is when you look at the damages aren't there.
The real damages are ones that are illegal.
Right. The real damages, if you admit, hey, what we were hurt because Xavier Lucas was going to play corner for us and be our best player, and he's gone. You can't say that, because in the bigger lawsuits, right, the big antitrust lawsuits where lawyers are making millions and millions of dollars and that are shaping the future of the sport, you're saying it's not pay for play. So you're walking a fine line in this smaller lawsuit to make arguments that cut against you in the big lawsuit. That's, to me, the fundamental issue with this case, and has been since the beginning. But anyway, so in this case, no damages. What are they going to say? We lost the value of Xavier Lucas's charming personality in commercials. That's not, there's no damages there money-wise. And you can't get specific performance, personal services, meaning you can't say, hey, court, make Xavier Lucas line up in the defensive backfield for us and leave Miami. You can't do that. That's too close to like modern day slavery. You cannot do that. That's like basic 101. So there's no real relief other than the court blessing the contract. So what Miami is saying is, look, Wisconsin's trying to get the court to just bless this whole model of Big Ten football. And it's not about this case and Wisconsin's legal rights in this case. They're just asking the court for an advisory opinion, basically. Hey, court, tell us that this is legit broadly. We're not really harmed by this. This is not something that's going to impact us, but we just want you to do this because we think it's good for you. That's not what these courts, they're taxpayer funded, right? You're paying for judges, you're paying for clerks, you're paying for everything. So to waste time and waste taxpayer money trying to figure out things that aren't really a part of a dispute, but that are just answers that Wisconsin would love to have going forward, or the Big Ten would love to have going forward, you can't do that. So that's the last part of this argument, is that this is a BS declaratory judgment claim. And you would love the court to tell you what this contract means for the sake of Big Ten football, but that's not a proper use of judicial resources to settle disputes. So lawyers in the chat, if I missed anything or if I said anything incorrect, let me know. But that's how I'm reading this introduction to this motion to dismiss, with all the disclaimers that I haven't read the motion in full. I haven't seen the case law, but just kind of big picture, I think that's what we're talking about here. Is it going to succeed? Wisconsin's going to respond. I'm not an expert on Wisconsin civil procedure, but maybe Miami will get a reply to that that opposition. They'll set it for hearing. Usually something like this, you're going to have to set it for like a longer hearing, right? You don't just want to, like, sometimes you have these 5-minute hearings that it's like a cattle call. There's a ton of lawyers in different levels of expensive suits in a room, and you're kind of running through these things. Whereas it's something like this, you're going to have to reserve a lot of time. In Miami, in state court, that always takes a lot of time in advance. Like, you have to book, sometimes months, almost a year in advance. Sometimes it feels like the calendars book up. I don't know how it is in Wisconsin, but the point is this part of it, which is an early knockout blow, takes a long time to get resolved because Wisconsin's got to respond. You got to set the hearing. You got to have the hearing. Then the court's got to make their opinion. So it takes a long time is the bottom line on that. So we'll see. But I think this was not surprising that they went this route. And I would say when you write something like this, you usually put the arguments in order of what you think is more likely to succeed. That's just our rule of thumb. So when I see this, I read this as Miami thinks their personal jurisdiction arguments are the most likely to succeed at this stage. And then the actual, hey, their claims failed to state a cause of action because there's no contract, all that stuff, advisory opinion, and it has lower down on what they believe is the stronger argument. So that's how I read it. But big picture, Xavier Lucas, when Miami goes to scrimmage tomorrow, he'll be playing corner. He'll be 6'1". He'll be 200 pounds. He'll be 4'3", and he'll be playing for the University of Miami. And this is really about things I think that are bigger than Miami and Wisconsin at the end of the day. But Miami is going to fight hard, and I think they have a pretty good hand. So we'll see how this one goes.
Great stuff, D. I wanted to get into the comment that you made about Mario and Fickle being a close fight. I got Mario easy there.
Yeah, no. I mean, look, if it was Mario and Manny, it'd be like that's like a jobber. But I mean, in terms of Mario and Fickle, at least that's a good opponent. But 904 saying Mario knows judo, mixed martial arts, actually competed in jiu-jitsu tournaments. Fickle wouldn't stand a chance. No, listen, I'm betting Mario every time. I'm betting Mario every time. But look, at the end of the day, Xavier Lucas is going to play for Miami here. Wisconsin's got a lot of problems. That program has fallen on very hard times. There's a proud program that's been good for a long time. They kind of suck now. I don't see them getting out of that, and I'd be frustrated if I was Wisconsin too. You lost a great player, but tough luck. Good luck finding a guy that's 6'1", 200 pounds, runs a 4'3" in Wisconsin. So we'll see how this
found
plays
him.
out.
They found him before. They just couldn't keep him.
That's right. They did find one. Well, not in Wisconsin. They found one down here, and I think down here.
Yes.
They're poison in the well down in South Florida. I mean, I can't imagine what a coach sending your kid to Wisconsin when you have to deal with all this kind of stuff. I wouldn't. I mean, this is to me.
It certainly hurts the South Florida connection, which they've gotten kids in the past from down here. So,
yeah. So we'll see how this one goes. But knowing how long this stuff takes, it'll take a while. Wisconsin State Court, again, I'm not an expert in it. My knowledge of Wisconsin State Court, at least in the criminal context, is from that Making a Murderer show, and it looked like a complete clown show. So, we'll see how it goes.
So you want to talk some football?
Let's do it, Pete. So comment here to get you started from Josh Gross, and he says, Pete, the work is awesome. If you ain't in the Discord, go